Again, good afternoon. Thank you for joining this session. This is Robert Campbell. I am the research consultant for Employers Group. This session will be on new NLRB rules and the impact on non-union employees. We are pleased to have today as our speaker Mr. Eric Becker from Senior Partner at Cummings and White. Eric Becker leads the Labor Employment Practice Group at Cummings and White. With 30 years of practical experience in labor and employee relations, his expertise centers on helping employers maintain compliance with the migrant laws and regulations governing employment. He also advises employers on strategies to maintain their union-free status and assists unionized employers with negotiations, contract administration, strike management, and communications. Mr. Becker also represents employers in all areas of employment litigation and has extensive experience handling matters before administrative agencies, including the NLRB, the EEOC, and California Labor Commission. He works with clients in a wide variety of industries, including instructions, manufacturing, transportation, nonprofit, and healthcare. Mr. Becker teaches a course on human resources and the law for the Human Resources Management Program at the University of California, Irvine, and regularly speaks on employment and labor issues for industries and professional organizations. At this time, I will turn it over to Mr. Becker.
Thanks, Robert, and good afternoon, everybody. Thank you for attending this webinar. I have a confession to make at the very outset. I was really kind of excited and geeked to be able to speak on this topic, and I want to thank Employers Group and Robert for inviting me to speak today on this particular topic. The reason why I'm kind of geeked about it is because I've been dealing with labor unions throughout my career. As a matter of fact, I was in union negotiations this morning. So when it comes to issues involving the National Labor Relations Board and labor unions, that's definitely in my wheelhouse. The second reason I was excited about it is there is a lot going on in this area right now, a lot of topics to cover, and I'm going to cover some of the major issues that impact non-union employers today. But there's a whole host of things that have happened and is probably coming down the road with the NLRB. And the third reason is because, as the title implies, a lot of this affects non-union employers, and that's not historically what the NLRB has dealt with. And so for all of you out there that never really had to think about the NLRB. Unfortunately today I'm going to tell you why you need to start thinking about their rulings and how that would affect your workforce and your policies and your procedures. So as Robert mentioned, if you do have questions during the course of the webinar, please type them into the chat. I'm going to be stopping on regular occasions and asking Robert to throw some questions at me from the chat if there are any. And of course, we should have some time at the end to answer any other questions that you may have. So let's get started. As I alluded to at the outset, I think today is going to provide some answers as to why you should care about the NLRB, even if you are a non-union employer. But let me just talk in general about some background on the NLRB and what's been happening over the past 2 years. The NLRB mainly focuses on disputes involving unions. So the NLRB is a federal agency. It handles labor relations throughout the country. And for the most part, what it deals with is what's called unfair labor practice charges. Charges by either an employer against a union or a union against an employer, alleging that they violated some provision of the law. And usually this is where unionized employers get involved. Very infrequently do non-union employers get involved. Usually when it comes to unfair labor practice charges, it has something to do with an allegation by the union that the employer is bargaining for a contract in bad faith, or that it terminated a union employee and did so because of their union activity, something like that. So traditionally, most non-union employers, unless they were subject to a unionization effort, didn't have to deal with the NLRB, because that's the other thing the NLRB does. It oversees a process if employees want to become unionized. And there has been a significant change that the NLRB pushed through this year on that process that I'm going to address at the end of this webinar. So generally speaking, in the non-union area, we haven't had to deal with the NLRB that much. But one of the things that you have to recognize is the NLRB is a political organization. And what I mean by that is that who staffs that organization at the top, which is the National Labor Relations Board, 5 members in Washington, D.C., and a position called General Counsel, which is kind of like the district attorney of the NLRB. The General Counsel is the one that prosecutes cases either against employers or against unions. Those folks are political appointees, meaning that the president appoints a majority of the people on the board, and the president appoints the general counsel. And every time we have a new president, depending on their political affiliation, the membership of the NLRB and the identity of the general counsel changes. So we have a president now that has appointed a majority of the board and the general counsel that is avowedly very pro-union. And as a result of that, we've seen a significant change in the decisions coming down from the NLRB and their approach towards employers over the past 2 years. The current NLRB is more favorable towards unions than ever in history. I've been practicing in this field for 35 years, and this is unique and unprecedented in terms of the decisions that the NLRB is issuing and how favorable they are towards unions. And we will have at least probably another 2 years of NLRB decisions that are going to be heavily skewed in favor of unions. And that's just the nature of the politicization of the NLRB. If the president changes, then the NLRB flips and the general counsel flips. And during the Trump administration, for instance, the NLRB was issuing decisions that were more favorable towards employers. Now, one of the things that's happened with this new board is they have definitely, I think, intentionally sought to increase their impact on non-union employers. And because of the decisions that they've issued that I'm going to be talking about today, the effect that they have on non-union employers is expanded dramatically, as we'll talk about. So what the board has done, and the general counsel has been part of this because the general counsel is the one that decides what cases get brought to the board. What they've decided is that we want to issue rulings that are much broader in terms of their effect than just on unionized employers, because their view is that a lot of the rules of this act, the National Labor Relations Act, have broad impact on all employers. And in the past, the NLRB has been too restrictive and only focusing on union employers, and we need to broaden that out so that we're affecting all employers. And that's what's been happening in their rulings. So one of the key rulings that has come out as part of this initiative to affect all employers has to do with work rules and policies. What's generally in your employee handbook regarding what employees can or cannot do in the workplace. And I'm not going to get too far into the weeds in terms of the legal decisions and all the precedents that have come before. I just want to focus on the case that came out this year and not too long ago in just the early fall. And that's a decision called Stericycle. By the way, NLRB case names are just the name of the company. So Stericycle, name of the company, that's the case name. And in Stericycle, the NLRB issued a new standard on how to judge the legality of any workplace policy. And let me give you a little background on where the NLRB is coming from in terms of what makes a policy legal or illegal. So there's a section in this law, the National Labor Relations Act, called Section 7. And Section 7 gives certain rights to employees. And the most important right that's in Section 7 is that employees have rights to engage in what's called protected activity. So, for instance, under Section 7, employees have the right to engage in activity on behalf of a union, talking to their fellow coworkers, advocating for unionization. That is a form of protected activity. But Section 7 is much broader than that. Section 7 protects any type of activity where employees advocate regarding terms and conditions of employment, and they're doing so in a concerted manner. In other words, it's not just an individual complaint, it's a complaint or an issue that they're bringing up on behalf of other employees. And we'll talk a little bit later about another decision that has even broadened that further. But for right now, Section 7 basically means that if an employee wants to complain about something or wants to talk about something having to do with their terms of employment with management or with other workers or even outside the company in the media, let's say, that is protected. And so the NLRB under this board wanted to make sure that there was a standard that protected employees from policies that could restrict or chill their rights to engage in this protected activity. And so this new standard that the board adopted in Stericycle basically says if an employee could reasonably construe a policy to chill protected activity, not to prevent protected activity, not to forbid protected activity, but just to chill it, just to make it a little bit scary. If an employee were to engage in protected activity, it is going to be presumed to be unlawful. So the presumption is any policy is unlawful if the employee might believe that it chills protected activity, unless the employer proves a couple of things. So in order to prove that your policies are legal under this new standard, the employer would have to prove it had a substantial and legitimate purpose for the policy, and it could not have achieved that purpose by a more narrowly tailored policy. In other words, the employer has to show not only that, hey, we had a really good reason for this policy, but furthermore, that there was no way we could have furthered or achieved the purpose of this policy with something that wasn't so broad, with something that was more narrowly tailored. So it's a new standard, and it's very much leaning towards protecting those employee activities, and therefore the NLRB using this standard is likely to find that a lot of policies that we take for granted in our handbooks or in our work rules are going to be unlawful. So what's the practical impact of this new standard? Whatever you intend when you adopted this policy, hey, we adopted this policy because, let me just give you an example, we want to protect our confidential information. And so we had no intent to infringe upon employees' rights to talk about their coworkers regarding terms of employment. We just want to protect our confidential information. That's irrelevant. The NLRB says we're not going to take that into account. And how you have applied the policy. Hey, we've never applied the policy to prevent employees from talking to other employees about their terms and conditions. We've only applied the policy in situations where people have blabbed about our confidential trade secret information. Again, that's irrelevant. The NLRB says it doesn't matter what you intended. It doesn't matter how you've applied the policy. If employees might believe that that policy would prevent them from engaging in that activity, it's unlawful. Unless you can show a substantial legitimate purpose, and you could have achieved it through, you could not have achieved it by a more narrowly tailored policy. So you can't argue under this standard that the obvious or practical interpretation of a policy makes it lawful. You can't argue, hey, most people would know, and it's pretty obvious that this policy doesn't apply to employees talking about terms and conditions of employment. It only applies to trade secrets. That argument is going to be discarded by the board, because the board is going to say, look, this could reasonably be construed to chill protected activity. And so it doesn't matter whether it's an obvious interpretation. If an employee could reasonably believe it, it's unlawful. So the other practical impact is it's very difficult to prove that a more narrow policy was not possible, because the NLRB can always argue that, hey, if you just made this a little bit more wordy and you just put more caveats in it and so forth and so on, you could have made this more narrowly tailored. It's very difficult to prove that your policy is not overbroad without writing a paragraph for each particular work rule. So the practical impact is the NLRB has made it very difficult for employers to defend these work rules if they're ever challenged. So what are some of the potentially unlawful policies that the NLRB through the General Counsel has identified as policies that might be unlawful under this new Stericycle standard? Well, number one, workplace civility rules. You probably have something in your handbook or in your work rules that says that employees cannot engage in rude or discourteous behavior towards customers, fellow employees, management. That is overbroad because under this new rule, because when people advocate on behalf of something that they feel very strongly about in the workplace, they might engage in discourteous behavior. And if I raise my hand in a employee meeting and start challenging a supervisor about how they've been applying a certain policy, is that going to be construed as discourteous behavior? So the NLRB would very likely say that a broad workplace civility rule is overbroad and unlawful under this new standard. What else? Policies that prohibit people from engaging in disparagement of the company. So a non-disparagement work rule. Employees cannot disparage the company, their fellow coworkers, managers, or the company's product or services. That would be construed as unlawful, because one example of protected activity would be talking to your fellow coworkers and telling them that I think our manager stinks. She's horrible. Well, that's disparagement, but that's also protected activity. So this type of rule under this new ruling would be considered overbroad. I already mentioned confidentiality provisions. Confidentiality provisions that would prevent employees from talking about or disclosing information regarding their pay or personnel issues or complaints or investigations even. This board, this NLRB is going to look at as overbroad under the Stericycle rule, unless you can show that a more narrowly tailored policy could not be achieved. Social media restrictions. There's been a lot of cases in the past about social media and whether restrictions on employees communicating through social media violates the act. I think that through this new ruling, the NLRB is going to take a much more a view towards social media policies that leans on saying that anything that would restrict employees from engaging in talking about or communicating about terms and conditions is going to be unlawful. Use of company email. If there's a broad prohibition on employees using company email for any non-business purpose, that could be construed as overbroad. Use of cameras or recording devices. Policies that say that employees cannot use their iPhone you know, handy dandy, we all have them, right? Use their iPhone to record or take pictures or video in the workplace. Well, part of protected concerted activity might be taking pictures of unsafe conditions in the workplace. And so that type of broad policy is likely going to be considered unlawful under Stericycle. Prohibiting comments to the media, insubordination. This is one I want to focus on because a lot of work rules, and I've written them myself, talk about insubordinate behavior as grounds for discipline. Well, this NLRB would say that that type of broad prohibition on insubordination is probably unlawful because people could engage in insubordinate behavior under the really broadest definition of insubordination, and it could be construed as protected activity. I mean, if I talk back to my manager, is that insubordination? Under the broadest definition of it, yes. And that could be protected concerted activity. And so the NLRB would say, look, you could more narrowly tailor that prohibition on insubordination to make it clear what exactly it is you're talking about. And so that employees understand that it doesn't prohibit them from just talking back or even getting upset with the manager over a certain policy or practice or their pay. So those are the kind of policies that we have to take a really hard look at in our employee handbooks. And the reason this is important is it's not an absolute certainty that your handbooks are going to get challenged by anybody. I mean, the chances of somebody coming along and knowing about the an employee, right, knowing about the National Labor Relations Board and saying, I'm going to file an unfair labor practice charge against my work rules is probably pretty slim. However, there are some pretty significant consequences if it does occur that a charge is filed challenging your policies. And let me give you some scenarios where that could happen. Let's say you terminate an employee based on an insubordination rule, for instance, and the employee either himself or herself or finds a lawyer and says, hey, that's an unlawful rule because it's impermissibly overbroad. They could bring a charge with the NLRB and say the termination itself is unlawful because it is based on an unlawful rule. And the NLRB would likely say, correct. You can't terminate somebody based on an unlawfully overbroad rule, and therefore we're going to overturn this termination. That is a possible scenario that could come about. If you ever have the unfortunate circumstance where a union starts to organize your employees and you have unlawful rules and policies in your handbook, that union could file an unfair labor practice charge. And as we'll talk about at the end of today's webinar, they could seek a bargaining order. And I'll explain what that all means. But basically, let me cut to the chase. A union could say to the NLRB, hey, this employer has unlawful policies in their handbook, and therefore you, NLRB, should impose the union on that company. In other words, even if the employees don't want us, NLRB, you should still require the employer to recognize us and bargain with us. Pretty serious consequence. So those things are not likely, but if they do happen, it can really cost a lot of money and a lot of heartburn for your business. Now, one other thing that oftentimes comes up, and probably a lot of you have this in your handbooks, is a savings clause. And that's just a general clause that basically says nothing in this policy, and I'm quoting what typically you see in a handbook, nothing in this policy should be construed to prevent employees from exercising their rights under Section 7 of the NLRA, such as the right to discuss terms of employment with others. And there's been a feeling in the past that maybe if you have that savings clause in the handbook, that would protect you from a charge that your policies are impermissibly overbroad and unlawful. I will tell you that although it's probably a good practice to have that in your handbook policies, especially for each of the policies that are the ones that the NLRB is really scrutinizing right now, the NLRB and the General Counsel have made it pretty clear that it's not going to save an unlawful policy. Even if you have that clause in there, if the policy is overbroad and it infringes or chills employee Section 7 rights, we're still going to find it unlawful. So it is not a get out of jail free card. So just keep that in mind when you're going back to look at your policies. So what do we need to do now? Okay, couple of things that I would recommend. Number one, if you have rules that are duplicative or unnecessary, get rid of them. A lot of times I see in a handbook where you've got, 3 different rules that touch on civility, right? If we're going to have a civility rule, let's just have one rule. The more rules you have that are kind of saying the same thing, the more chance somebody's going to challenge them as overbroad. And then you've got to rewrite your overbroad rules. You've got to narrow them down. For instance, let me give you just one example, insubordination, right? As I said earlier, insubordination can be defined very broadly. So what you need to do with your insubordination rule is say something along the lines of insubordination meaning refusing to follow a direct order or directive of the employer. So in other words, it's refusing to follow an order. It's not talking back. It's not complaining. It's, I need you to go move that machine from there over to there. No, I won't do it. That's insubordination. So you have to more narrowly tailor it so employees understand, hey, this is the thing I'm going to get in trouble for, refusing an order. You need to focus on, when you talk about civility or disparagement rules, conduct towards customers and other stakeholders that are external. Where it becomes a problem is when those civility rules say that you can't be rude towards management or fellow employees. Because especially in this world, in this day and age, being rude, the NLRB considers protected activity. So the more you can focus on, don't do this with customers, don't do this with vendors, that does not run afoul of the protected activity restrictions. The other thing you can do to help defend, if you do get one of these challenged, is to have the business justification for the rule included as an appendix to the rule. In other words, if you have a camera and recording prohibition rule, okay, you could say recording using a camera or cell phone, either visually or video or audio, is prohibited in areas where the company has trade secret information processes. These are the areas, and the reason is to protect the business, the confidential business information of the company. That would help you if you had to defend against the legality of that rule, because not only is it more narrow, it also has the business justification written in, making it very clear to employees why you have that rule. And then also tie your rules to other important policies. For instance, your civility rules. Tie it back to the harassment and discrimination prohibition, because that narrows down that rule. So there's a lot of things you can do. The last one I would mention is use examples to illustrate what would be a reasonable interpretation of the rule, right? So you've got a rule that prohibits employees from engaging in rude or discourteous behavior towards customers, such as yelling at customers, refusing to respond to their questions or requests, etc. Those are some of the things that you could look at to help protect yourself against a claim that your rules are unlawful under this law. So let me stop right there and ask if there's any questions, Robert.
No, Mr. Becker, no questions at the time.
Excellent. So let's move on and talk about a couple of other rulings that have come out restricting how employers use certain employment agreements. And one of those is severance agreements. So probably you've all seen a very, basic separation agreement that you offer an employee, have them sign, waiving their rights to pursue any type of lawsuit against you in return for severance. And there was a decision that came out this year. Again, the name of the case is McLaren-Macomb. And that decision, the NLRB said certain provisions in severance agreements violate the National Labor Relations Act. So they didn't rule that you can't use separation agreements. They did not rule that they are per se unlawful. So we can still use separation agreements. What they said was if you have a unlawful term in that separation agreement that you've offered the employee, even if the employee doesn't sign it, it's still a violation of the act. So they're not going to throw out the whole agreement as unlawful, but if you've got unlawful terms in an agreement and it's challenged, that unlawful term is going to constitute a violation of the law. So what are the terms they are calling into question that are violating of the National Labor Relations Act? And again, this all goes back to Section 7. They said that certain terms in separation agreements violate employee Section 7 rights, or at least could reasonably be construed as chilling Section 7 rights. So, non-disparagement clauses. We already talked about that in terms of employer policies, but very often in a separation agreement, there'll be a clause that says the employee agrees not to disparage the employer or its products or services after employment. And the NLRB said that's overbroad because a former employee still has Section 7 rights, and they could talk to some of their fellow coworkers about certain problems at the company, and that would be protected activity. So the NLRB was very specific in saying, look, you can have a clause that prohibits the former employee from defaming the company or defaming the company's products or services, but non-disparagement in general is overbroad. They also pointed out in McLaren-Macomb that a general confidentiality provision is overbroad. Most separation agreements in the past would have something that said that the employee and the employer agree to keep all the terms and conditions set forth in the agreement confidential. And the NLRB said, no, that restricts employees from talking to, for instance, a coworker that has a question about a severance agreement that they were offered. And so that is overbroad. Most separation agreements have provisions that release any and all claims arising under the typical employment laws, right? Wage and hour laws, the Fair Employment and Housing Act, WARN, FMLA, CFRA, et cetera. The NLRB said in McLaren-Macomb, you can't have a clause that releases claims that the employee could bring under the National Labor Relations Act on behalf of others. The employee can release their right to file an individual claim based on their termination, but they can't broadly release all claims that they could bring under the Act. Oftentimes, these agreements have provisions that require employees to cooperate in any further litigation. The NLRB once again said in McLaren-Macomb that was probably overbroad because they could bring litigation against the employer after they leave employment on behalf of other employees, and you can't require through this provision that they cooperate with you. And then this is one that is, I think, concerning. The general counsel, at least, is calling into question non-solicitation or poaching prohibitions in separation agreements or any type of employment agreement. And these are clauses, of course, that say the employee agrees that they will not solicit or entice employees to leave employment with your company and go elsewhere. And at least theoretically, now McLaren-McComb didn't specifically say this, but the general counsel is arguing in subsequent cases that those types of clauses infringe upon the Section 7 rights of employees to leave their employment. And it infringes on the rights of former employees to talk to their former coworkers about employment opportunities elsewhere. So as you can see, the way the board is going is they're really trying to expand the impact of these laws and say, oh, this just doesn't apply to union employers. This applies to every employment type of document you have and every type of employer regarding things like non-solicitation. So that's definitely something to keep an eye on. But what's the practical impact here? So even if you have unlawful provisions, your severance agreement is not unlawful. The NLRB said in McLaren-McComb, what we would do is if this ever came up to us where there was a signed agreement that was unlawful, we would just blue pencil or strike out those unlawful provisions. Also, this doesn't apply to supervisors or managers, only non-exempt employees, because supervisors and managers are not covered by the National Labor Relations Act. So if you have severance agreements that you're offering to people who are in supervisor or above positions, you can still have some of those provisions, such as non-solicitation, non-disparagement, et cetera, and they would not be subject to an unfair labor practice charge before the NLRB. One thing in McLaren-McComb that they did specify is that it is not unlawful to require confidentiality regarding the amount of severance. So you can restrict employees from talking about how much they got. You just can't have a broad restriction on them talking about anything having to do with the agreement. And the reality is it's probably unlikely that we're going to get a lot of ULPs arising out of severance agreements because of what the NLRB said is we're not going to void the whole separation agreement. We would just void the unlawful provisions. Nevertheless, I think it's a good idea, particularly if you have an older severance template, to go back and look at it and make sure that it's updated so that you put in those savings clauses in those various areas, for instance, in the release, saying this does not apply to any claims the employee may have on behalf of other employees that they could bring before the National Labor Relations Board. You'd want to have that in there just to carve that out so that there can be no challenge to the release. I would include non-disparagement on a case-by-case basis. So if you're really concerned about a former employee that may go on Glassdoor and Indeed and badmouth the company, maybe you take the risk and include it in there. And certainly for supervisors and managers, you can include it. So I would definitely not just include it as a matter of course. So moving on, there is also a ruling that came out regarding protected concerted activity. I talked about protected concerted activity earlier, and I just want to briefly touch on the expanded definition under Miller Plastic Products. That's the name of the case that came out. So in order for activity to be protected under Section 7, it's got to be something having to do with terms and conditions of employment. That's what makes it protected. And it also has to be concerted, meaning it can't just be an individual action. It cannot be something that is designed solely to raise an issue or complain about an individual thing that I want, right? So if I go into my boss and say, hey, boss, I want a raise, that is not concerted. I'm not asking for raises for anybody else. I'm not mentioning anybody else. That is traditionally been considered unprotected because it is not concerted. So in Miller, the board tried to expand this definition and said even individual complaints can be concerted in certain circumstances. So even in a scenario where other employees don't support the complaint or the advocacy or join in, or the employee doesn't discuss it with anybody else, even in all those scenarios, it's possible that it could be concerted the NLRB basically said, look, we're not going to look at whether or not employees joined in or didn't join in, or whether or not the employee talked about this issue with other employees, because the old rule said unless you have something like that, it's not going to be concerted. We're just going to say if it has some relation to group action based on a holistic approach, then we're going to find it to be concerted, which is another way of saying we don't want to be bound by any rules. We'll decide what's concerted and what isn't concerted depending on the circumstances, which of course makes it more likely that the NLRB could find certain conduct concerted, even if there's not evidence that it was designed to advocate on behalf of others, or that others were aware or joined in. So I think it's the practical impact of that is we're going to have more opportunities for employees to challenge terminations by filing an unfair labor practice charge and saying, hey, I was engaged in protected concerted activity and they fired me because of that. So don't assume when you have one individual coming in and complaining about a policy or a practice that it is unprotected. You got to look at the situation, and just like any other whistleblower situation, think very carefully and look very closely at it before you decide whether or not you're going to terminate the employee for that particular conduct. And if they're arguably engaged in protected activities, you might want to consider alternatives to termination, discipline short of termination to try to address the issue, rather than just jumping right into a termination that could get challenged in front of the NLRB. So it's really important to keep this in mind as you're going through your checklist of determining, okay, is there any risk associated with this termination? Is the employee coming off an FMLA CFRA leave? Has the employee asserted that they're disabled? Do they fall within other protected classifications? Have they engaged in whistleblowing conduct? And did they engage in something that could be construed as protected concerted activity? Okay, any questions, Robert, before I finish up with my last topic?
No questions at this time.
Fantastic. So I wanted to finish with one of the again the headlines here. Really big change that the NLRB pushed through late this year, and even if you're non-union, this could impact you down the road. So it's really important to be aware of this. And this is a ruling called CEMEX, and here's the headline: CEMEX makes it much easier for unions to organize non-union employers. Now, let me go back and explain why. So the rule has been, ever since I've been doing this for 35 years and going back farther than that, 50 years, the rule has always been that if a union comes in and says, hey, we represent a majority of your employees and we want you to recognize us, we want you to unionize, the employer didn't have to respond. The employer could say, I'm not even talking to you about it, get out of here. And that's always been the rule ever since I've been practicing. And the standard procedure for unions has always been, if they want to organize a group of employees, they file what's called a petition with the NLRB, and that petition would ask the NLRB to conduct a secret ballot election. So the standard procedure has been that if they get 30% of employees to sign something saying they want to be unionized, they can go to the NLRB and file for a secret ballot election. And that's always been the way it's done. And then the employees vote on whether or not they want to be unionized. And if a majority vote yes in favor of unionization, the union becomes their representative, the union wins, and you got to bargain with them. If the union doesn't get 50% plus one, they lose, and you don't have to bargain with them. If they never get 30% of the employees to sign anything, they never get to file a petition. CEMEX changed all that. Under CEMEX, unions do not have to file a petition for an election. Instead, a union under this new rule, can make a demand for recognition based on having majority support. So a union could have a meeting, and let's say your company has 50 employees, and 30 of them show up at this meeting because they want to hear about unions. And the union says, okay, so how many of you are interested in maybe being unionized? Everybody raises their hand. Okay, we're going to take that as majority support. We are now going to go to your employer. They don't have to tell the employees this, by the way. We're now going to go to the employer and say, look, we represent a majority of your employees. We are demanding that you recognize us as the bargaining representative. And if a union does that, either verbally or in writing, so it doesn't have to be in writing, they can walk up to a manager or supervisor and say, hey, I'm from the union, we represent a majority, and we want you to recognize us. If they do that, again, it can be made to any agent, supervisor level or higher. Here's what happens. You have three options. You can either ask the union to produce evidence of their majority support and recognize them without a vote. You could say, okay, union, what's your evidence of majority support? Yep, we had a meeting and 30 of your 50 employees said they want to be unionized. Okay, I guess we've got to recognize you. Not a very good option. Second, you can file what's called an RM petition with the NLRB seeking an election. And we'll talk about how that will work. Third, you can refuse to bargain with the union and say, I don't believe you that you have majority support and you want to file an unfair labor practice charge against me, go ahead, and we'll litigate over whether or not you actually had a support from a majority of my employees. The problem with that, of course, is if the union does have evidence of majority support, you lose and you have to recognize and bargain with the union. You can't take option number 3 and say, oops, you have majority support, now I want to file an election. So either you ask them to produce the support and recognize them, you file for an election, or you take your chances with challenging it in litigation and you hope they don't have majority support. So if an employer wants to remain non-union, probably the best course of action is going to be to file an RM petition to seek an election. Now, the rules under CEMEX changed in terms of what you have to do to file an RM petition. And this is the most important part of it. You have to file within 14 days of receiving that demand. Otherwise, if you miss that window, the union's automatically recognized. You are a day late and $1 short. So it is very crucial that if you are going to seek an election, you do so very expeditiously so you don't miss that window. You can also, if you file a petition, challenge the scope of the unit sought by the union. In other words, if the union says, we want to represent only the employees in the customer service department, you can say to the NLRB, hey, we don't think that's an appropriate unit. It should include all non-exempt employees, and then you can litigate that issue, but only if you file an RM petition. If you do file an RM petition, the NLRB is going to conduct an election within 21 days. So it is a very quick time frame. You don't have a lot of time to think about it. You have to gear up for an election and gear up for a campaign to convince employees not to become unionized, because it's going to happen within 3 weeks and they're going to vote. So it is a very compressed time frame. So here's the other main thing that changed with CEMEX, and I referenced it earlier, and it has to do with bargaining orders. What the NLRB said in CEMEX is, if the union demands recognition and you commit any unlawful act after that, we are going to issue a bargaining order, meaning we are going to order that you become unionized. So the prior rule was, if you had unlawful acts prior to an election, and I'll give you an example. Amazon had an election, I think it was in 2022, big election down in Alabama. Voters overwhelmingly voted against the union, but the union filed what's called election objections, saying, hey, Amazon put a mailbox close to the plant so people can mail back their ballots, and that's interference with the election. And we think you should overturn the election. And the NLRB said, yep, we agree. We're going to overturn the election. But they didn't issue a bargaining order. They said, no, we'll rerun the election. Okay. Even if the union previously had majority support, usually the NLRB would only issue a bargaining order if there were serious and multiple violations, such that it was impossible to have a fair rerun election. The board in CEMEX said, no, we're throwing all that out. Any one ULP, any one violation of the law can result in a bargaining order, even if the union actually lost the election. Even if you go through that vote and a majority of employees say, like they did at Amazon, no thanks. If it's found that the employer committed an unfair labor practice, we're wiping that out and you got to recognize the union. So what kind of things could result in a bargaining order? Discipline or discharge of union supporters, automatic bargaining order. If it's proven that you took that disciplinary or termination decision based on their union activity, that's automatically going to get you a bargaining order. Other unlawful acts. We talked about maintaining unlawful policies in your handbook, interrogating employees about their union activity. What the NLRB said is that unless the activity was so minimal or isolated that it is impossible that it affected the election, we're going to issue a bargaining order. I think it's an impossible standard to meet. How can you prove that it was impossible that your unlawful policy on non-disparagement didn't affect the election? They've really set employers up to fail here. Basically, what they're saying is, if a union demands recognition and you do anything wrong, we're going to order that the union be recognized. So, what are some of the key takeaways here? Number one, have your policies and work rules reviewed for compliance. Make sure that you're looking at those rules and tailoring them narrowly. Number two, don't take an older severance agreement template and roll it out without having somebody look at it and update it for these new NLRB rulings. Next, take protected activity into account when you're analyzing your termination decisions, as I mentioned before. And more importantly than probably all the above, even if you've never had any type of union activity, even you're not in an area that typically is unionized, train your managers and supervisors. They need to understand how to lawfully respond in the event of union organizing, because anything they say and do after there's a demand for recognition could result in a bargaining order and could result in unionization, even if the employees don't want it. So really important that you pay attention to that, because it is a sea change in how unions organize, and it really puts employers behind the eight ball. So really important that you look at that in the new year and take steps to harden the target against unions coming in and demanding recognition. Okay, finally, in 2024, keep paying attention to what the NLRB is up to. They have a lot of initiatives on the plate from the General Counsel. Let me just give you one example. Doesn't affect us much in California, but the General Counsel is now arguing before the NLRB that any type of non-compete agreement violates the act. So as we know in California, non-competes are not permitted, but in other states they are, and the NLRB is trying to get a rule put in place that you cannot use a non-compete in any type of employment agreement anywhere in the country. Really important stuff, so you gotta pay attention to what they're doing. Even if you didn't have to pay attention to them before, it's a different era. So here's my contact information if anybody has any questions afterwards, but we've got a couple minutes, Robert. Any questions in the chat?
No, Mr. Becker, no questions came in today.
Wow. Okay.
So
well,
you must have done a great job explaining.
Well, it's a lot of stuff to throw at you in a very short period of time. But I hope you found it interesting, and I hope you took a few key takeaways with you to help prepare you for 2024 in dealing with these new NLRB rulings. So I really appreciate everybody's attendance today. Thank you very much. And